they set 4 general civil matters for 10 o'clock and for a half an hour. And each case takes a half an hour. So I've got 2 hours of cases set in a half an hour. One of the cases has resolved, and the other one, the defendant didn't show up. So I think that's the hope, that it's always stressful when we get to this point. All right, so we're going to relabel ourselves as general civil motions. And address these matters one by one. All right, Miss Cleveland,
Yes.
you weren't here when your case was scheduled. I got your email. I shared it with Meg Bauer from Legal Aid, and she is here. So before we're done, I'm going to put you in a room where you can speak privately with the lawyer from Legal Aid, and we'll talk about your case.
Thank you.
All right. Let's address Discover Bank versus Esther Sudzia. Would you come up here and have a seat, please? Title of the case, as I indicated, is Discover Bank. Could you state your name for me?
Esther Smedzik.
Smedzik. Is there an M in there?
Yes.
Yes, there is. On the pleadings, there's no M, S-E-D.
Right.
But on the notice of hearing, it's Smedzik.
Yes.
All right. This distinguished Mr. Jeffrey Beers is here on behalf of the plaintiffs in this matter. This is a hearing on plaintiff's motion for summary disposition. This is a claim for $6,576.06 plus costs to bring the total to, that's the total, $6,576. They filed this action and you were served with it, and you filed a response in December, and you indicate that you acknowledge the debt and you're working with credit associates. A motion for summary disposition, and this applies in the Hart case as well, is a legal motion that's filed all the time in civil cases, but it's unfamiliar to lay people. It contends that there is no material issue of fact, and you haven't stated a defense, and a judgment should simply enter on behalf of the plaintiff. And that's what Mr. Beers contends. Mr. Beers, do you want to speak to that any further?
That's correct, Your Honor. This is plaintiff's motion for summary disposition arising out of a default on a credit card. There's been no written response to our motion, no documentary evidence filed by the defendant to rebut our exhibits. Therefore, our motion is unopposed. MCR 2.116G4 requires a written response. Otherwise, judgment shall enter against the defendant. The defendant, in her answer to the summons and complaint, as the court has stated, admits to the debt and wants to work out payments. As our motion is unopposed, we ask that it be granted and that judgment enter the amount of $6,576.06
for $9,249.40. This is also a hearing for summary disposition. Defendant did file an answer indicating that her financial situation changed when she was forced to retire, and she doesn't deny the debt, but doesn't presently have the ability to pay it. Is that correct, Ms. Hart?
Yes, that is, Your Honor.
I didn't open 2 breakout rooms. I only opened 1. Are you willing to talk with Ms. Dixit regarding potential payment plan?
Yes, that would be fine.
total amount they're asking for the order isn't very clear, Ms. Dixit. It doesn't have any numbers in it.
Yeah, sure. So, the court cost we are requesting would be 131.50.
All right, well, let's add it up. Damages are $9,249.40. And what are the court costs?
Yes, so the court costs are 131.50, and I can give a breakdown if needed.
No, that's fine. And so what's the total?
Oh, yeah, sure. So the damages are actually 9,239.51. So 9,239.51. That will be the
I
damage.
got 9,249.
I'm sorry, Judge. Not sure. I think they're. I'm not sure if there was a recent adjustment in my system, so I apologize. But I have it as 9,239.51.
All right. But as I said, the order doesn't have any numbers in it. So 9,239.40.
0.51, 9,239.51. And the
All right, that's
court
different.
costs. And the court costs are 131.50.
131 or 171?
131.50. Those are the court costs. 131.50. And the total, I do have the total over here. That will be the judgment. If granted, we would be requesting a judgment of total of $9,371.01. So it's 9,371.01.
All right. You're Mr. John Parker? Parker.
Yes.
Well, which case are you here on?
Let me grab the paperwork, please. It's
I couldn't get you to answer me earlier.
oh, I'm at work and I knew it started at 10:30. That's why I was. Okay, the case number is 25-1961-GC.
All right. United Federal Credit Union versus Dawn Heitker. How are you connected to that?
This is my wife. Her name was Heitcher when we did the loan for the truck, and it was mine.
All right, well, stick around for a minute.
Okay.
All right, Miss Hart, that's a lot of money,
Yeah.
$9,371. I've got people in the breakout room right now, and I'm gonna allow you to go into the breakout room with Ms. Dixit and discuss the ability to maybe set up a payment plan. This order I got
Okay.
is a bit lacking, but let's see how they're doing in the breakout room. I may need to open more than one room. All right, let me put you guys in a room 2.
All right, thank you, Judge.
And Natasha Dixit into room 2. That aside. All right, it is 10:24. We're doing better than I expected. Ms. Sudzik is in the breakout room. I have United Federal Credit Union. I have Attorney Carmen Pant here on behalf of that plaintiff.
Morning.
Good morning. And your P number is 88042.
Correct, Your Honor.
Mr. John Parker is here from work. The title of the case is United Federal Credit Union versus Dawn Heitker and John Parker. Mr. Parker is here, and Ms. Hiker filed a motion to set aside the default, but Mr. Parker did not.
I was with her when we did it.
All right. Well, let's back up. Yeah, your name is on it, Don Hiker and John Parker. The lawsuit was filed. You didn't file an answer. And they entered a default judgment, I did, on December 9th, in the amount of $15,888.22. A few days later, on December 16th, you and your wife came in and made a motion to set this judgment aside. There's certain rules that apply when you move to set a judgment aside, and it's in the plaintiff's brief. You bought a Yukon Denali
Yes.
for a lot of money, $45,000, and defaulted on it.
Yeah, but
Oh,
go
all
ahead.
right, well, just a minute.
Okay.
So when you move to set the default aside, you have to follow the court rule, which is 2.603D. And you have to show that there's a meritorious defense, and you're supposed to file an affidavit of meritorious defense, and you're supposed to show good cause why you didn't file an answer. So the plaintiff is objecting to the motion to set aside the default because you haven't stated a meritorious defense, and there is no justification for failing to file an answer. Ms. Pant, am I in the right neighborhood?
Yes, Your Honor. As you've indicated on the scale form that the defendants filled out, nothing was marked in regards to, I believe it was paragraph 2, where they could put their meritorious defense, as well as good cause. Nothing was included. So as Your Honor has stated, we're requesting that the default be allowed to stand.
Mr. Parker, what's your response to that?
I didn't know that I had to do something like that. We didn't know. We know we're not lawyers.
Well, that's
I know it's
happens a lot,
Yeah.
but the summons says on its face, you are being sued. You have 21 days to file an answer to this in big letters, and very often people don't. So the judgment entered. So there's one issue. You didn't file an answer. And two, you haven't stated any defense. You owe this money, according to the plaintiff.
Yeah, but
And go ahead.
yeah, but when at the time when we defaulted on it, we went to the credit union and talked to the lady at the credit union, and she said the first time would be they would take it back because I had got laid off, so I couldn't pay it. I didn't want to keep the truck for that reason.
Yeah, they never do that. Everybody, this is what happens in auto. People would say, turn it in. I can't afford it anymore.
Right.
That's not how it works. They
Okay.
take it, then they sell it at auction, and then they pay what they received at auction against the amount borrowed, and you owe the balance.
Right. I
And
understand that.
That's what this is. Where were you working?
Where I'm working right now, I had got laid off from at Winnebago.
But you're back to work now?
Yes.
Where's your wife?
She work at she at work. She work at Grand Design.
Well, you got two good jobs. You owe this money. You haven't stated any meritorious defense, and there's no good reason for failing to file an answer other than you didn't know you were supposed to. So the motion to set aside the default is denied. Would you like to try to set up a payment plan?
Yes.
All right, let me see if I can open
Your Honor, I'm actually just covering for the attorney of record, so I don't really have authority. But I can give Mr. Parker it's also included on our response, but I can give Mr. Parker our office's phone number so he can call and speak with the attorney of record to try and set up that payment plan. I apologize.
All right, well, that's what I would encourage you to do. The law firm's name, number, and everything is on the pleadings. It's Christ Enderly. Miss Pant, where are you located?
Our office is in Grand Rapids, but we also have offices in Kalamazoo and Battle Creek as well.
All right, so you're with the Christ Enderly firm, but you're not, okay.
Yes, Raymond C. Schultz is the attorney of record. I'm just covering the hearing for him today.
I'm going to put in here, defendant will contact plaintiff attorney and attempt payment plan. You owe this money, and it's a lot.
I know every time that we tried to contact the bank, they were saying that we didn't owe nothing because they was taking it to the auction and auction it off. We didn't know how much they received for it or nothing. They wouldn't tell us nothing.
These are probably my least favorite kinds of cases. Now, this isn't from an auto seller where they charge 21% interest. This was a financed nice Denali at reasonable interest rates, 6% or something. 6.2%.
Before I got laid off, I didn't miss a payment.
Yes, well, then you did. Then they repossessed the car.
I
They
took it
sold
to
it
them.
at a cheap price at an auction, and you owe the difference.
Okay.
So this goes under the category of paying for a dead horse. You're paying for a car you no longer own. And I do dozens of these in the course of the year. This one's better than a lot because it's a credit union loan as opposed to buying it from a payday car loan place where they charge very high interest rates. Anyway, I denied your motion to set aside the default because you've not established a meritorious defense or good cause for failing to answer the summons. So the judgment stands in the amount of $15,576 plus costs. Defendant will contact plaintiff attorney, Mr. Schultz, try to work out payment plan. All right, Mr. Parker, you're good to go. Ms. Pant, let Mr. Schultz know this defendant will be contacting him regarding trying to resolve it.
So I just contact them and we set up some type of payment plan.
Yes, that would be my suggestion.
Okay, that's cool.
All right.
Your Honor,
Very good. Ms. Bauer. All right, we're gonna go back to Discover Bank versus Esther Smedzik. Parties were put in a breakout room. Mr. Bears, what's the status here?
Good morning, Your Honor. We had an opportunity to speak in breakout room, and she's not really opposing the motion. We did talk about different payment offers and payment plans, and she wants to pay it. She's not contesting that. Unfortunately, the authority that Discover gives me on a monthly payment, we just couldn't meet on a payment amount. But I did give her instructions on how to get a motion for installment payments from the clerk's office and fill that out and ask for a lower payment that she could do. And then the court would set the payment. And so it's my understanding that's what she's going to do. And she's not really opposing the motion for this morning. And she's going to file her motion for installment payments.
All right, Ms. Smedzik, you can also share this with your debt consolidation company. I'll give you a copy of this order. And then before you leave, you can get that motion for installment payments. And the clerk will help you with that. But the motion for summary disposition is granted. And Mr. Bears, your motion's got the correct numbers in it. Plaintiff's motion for summary disposition is hereby granted. Damages in the amount of $6,421.16 and court costs of $154.90 for a total of $6,576.06. All right, Laura, could you come get this? I'm gonna ask you to go out to the counter. We'll give you a copy of this order and the installment payment petition. Share this with your debt consolidator.
Now, how much is the installment payments?
Well, I can set them.
Okay, because what I explained to him was, I can't afford the $275 because of the fact that I am on Social Security right now. But in May, 3 goes off.
Okay.
Okay, and in October, the discovery goes off. And I'm paying Credit Associate $600 a month. So that will free up. And from May to what would be September, they're saving $500 and some a month for me. And it will be in a lump sum that I can put towards this payment.
Well, it sounds like you've got a plan, which is more than a lot of people have.
Well, it's my debt. I explained to him what had happened. My husband had died of brain cancer. And 2 weeks after he had died, I was in an automobile accident. And
No,
then I had I had to retire.
What did you do?
I worked at American Axle, and
They're restarting 300.
I had fractured my breastbone, and
That's what it's been.
I chose to
I've
retire.
got some Kleenexes there.
So
you
but-
got a lot going on, and I can,
went down to $1,700 a month.
well, you have Social Security, only no pension?
No,
You didn't have,
only Social
you
Security.
didn't work at American Axle long enough to get a pension?
No, I wasn't.
Oh,
I
sorry.
didn't work there long enough. But if my husband would still be alive, I wouldn't be here.
This is, you heard the other people, they lost their job. Yours is, there's no shame in this. Your circumstances changed, but I can supersede what they're asking for and do a lower amount.
Well, see, I told him that
and-
I could do $100 a month
All right.
until October.
All right,
Well,
well,
it
you-
would be October.
You file that motion for installment payments and I can set it at that amount and we
Okay.
can make sure you have enough money.
And
to
I
pay
can
your-
start in March. It would be in March.
All right.
Would
Go
it-
out- go out
Okay,
to the
would
counter.
it be, like directly taken out of my account?
We can work that out.
Okay,
Yeah.
that's what I want.
All right.
Okay,
Mr. Bears, I think that's a good plan, and I don't think you frankly object to what she's proposing, but you don't have the authority to accept it. So, I can supersede it. So I'll be seeing you again on your motion for installment payments.
okay, so I will, when would that be?
Well, you get the paperwork and fill it out and the clerk will set it for a hearing.
Okay,
Right now, you don't have to pay anything. They
Well-
can't garnish your social security.
right.
Um,
Well, but like I said, this is my debt,
all right, fair
and
enough.
I know that. And if I would have $6,400, I would have paid cash.
I'm sure you would. All right, good luck to you, ma'am. I'm
Okay,
sorry
thank
for
you.
all your hardship. All right, Mr. Beers, we do see a lot.